Good afternoon and welcome back to everyone. I want to welcome you all to the next panel in this afternoon's agenda. This program is going to be titled Political Asylum and Permanent Protection in the U.S. I want to introduce myself to you first. I'm Karen Grisey. I practice at Fried Frank in Washington, D.C. I manage the pro bono program there on a day-to-day basis, and I concentrate my own practice in asylum and deportation defense in our pro bono program. I'm also a member of the Board of Trustees here at CMS. And on a policy front, I'm the immediate past chair of the ABA Commission on Immigration, an organization I know that several in the room have been associated with, including Don. And so we hope to bring you here a balance of the policy and the practical, the procedure and process, as well as the theory in U.S. asylum law. So first I'll start out with a thanks to Don and to CMS for putting together and in particular inviting us to this important program. I'm going to begin with introductions of the panel. For those of you who know Mario Russell, I'll start by telling you you don't need new eyeglasses. Instead of Mario Russell, who's been the subject of a court hearing rescheduling this afternoon, we're going to be joined by Mark von Sternberg. It makes the introduction of Mark very easy because I still get to say that he's a senior attorney at Catholic Charities of the Archdiocese of New York. The introduction doesn't get any more difficult, and Mark, of course, was very well introduced by Don earlier this morning, and we want to say thanks to Mark for joining us again and lending his expertise on this panel. Mark will be our first speaker, and he's going to be addressing trends and recent developments in U.S. asylum law. Following Mark, we're going to hear from Mary Ellen Fullerton. Mary Ellen is a professor of law on the faculty of Brooklyn Law School. You have her full bio also in your materials, but I'll note that she was in 2013 selected as the Fulbright Distinguished Professor of Law in Trento, Italy, and her work there focused on comparative refugee law with an emphasis on the EU. She's also the editor of an online resource tool described in your materials, the Refugee Law Reader, available online in 4 languages that may be of interest to many of you in your research and casework. And she's also the author of 2 casebooks, Forced Migration Law and Immigration and Citizenship Law. Mary Ellen is going to speak on the topic of statelessness and protection of the stateless by the U.S. asylum system, or perhaps the lack thereof. I also want to alert everyone that Mary Ellen has an article about to be published by the CMS Journal on Migration and Human Security, and that will be coming out sometime in the very near future and available online as soon as it's published. Our third speaker, moving from the law and theory to the policy and procedure angle on this panel, is Mark Nofri. Mark is currently a visiting associate fellow here at CMS in New York, and I'm happy to be among the first to announce that he'll be starting next week as a fellow for the Immigration Policy Center at the American Immigration Council in Washington, D.C. Mark has formerly taught civil rights and immigration at the Brooklyn Law School and clerked here in the Southern District of New York. Mark is going to be talking about detention, due process, and internal barriers to protection of asylum seekers. So I'm going to begin by turning it over to Mark to talk to us about trends and developments in U.S. asylum case law.
Karen, thank you so
You're
much.
welcome, Mark. Thank you.
And good afternoon once again. I'm going to confine my remarks with respect to current developments to 2 areas which are overwhelmingly significant. They are the use of past persecution to establish a claim to humanitarian relief, and the other, the crisis over social group adjudications, which has now come to a climax in 2 cases which I referred to this morning, matter of MEVG and matter of WGR. Begin with the latter 2 cases just for a moment, and by way of preface, in those 2 decisions, the Board of Immigration Appeals dismissed 2 claims that were brought for refugee-type relief by individuals one who had resisted being co-opted into a gang in El Salvador, and the other, the one in WGR, who actually had defected from the gang and feared serious harm as a result. Let me go back now and begin with my discussion of past persecution and humanitarian asylum. Past persecution and humanitarian asylum in the United States had its start, of course, in a case that we all know very well, the matter of Chen, a 1989 decision in which the Board of Immigration Appeals looked carefully at the definition of refugee set forth in Section 101A42 and decided that you did not necessarily need a well-founded fear of persecution to be granted asylum. Instead, the board opined that you could predicate a claim to international human rights protection based on past persecution standing alone. The language which came to support this type of claim was a showing that there were compelling reasons arising out of the severity of past persecution that would make repatriation inhumane. So Chen, which involved a young man whose parents and whose grandparents had been persecuted in China, was able to qualify for asylum based largely on these humanitarian showings. In 2000, regulatory reform expanded upon the notion of humanitarian asylum. And in 2000, it was decided that a showing of some past persecution, not necessarily severe past persecution, but some past persecution would also satisfy the standard for humanitarian relief if it were coupled with return to other serious harm. This is the provision which the Board of Immigration Appeals addressed in matter of LS. And this particular provision is the one which is coming to have revolutionary impact on asylum law. Why? It is coming to have dramatic impact on the development of asylum law because it really has taken asylum out of the notion of you need a well-founded fear of future persecution to succeed. Several years ago, I was trying the case of a little old lady who came from Haiti. She bore on her marks, on her legs, the marks of a scythe, which had been left there by the Tonton Macoutes, the Duvaliers police force. She herself was 85 years old. And to my own question, what would happen to you if you were returned to Haiti today, she responded, absolutely nothing. Nobody would touch me. And the judge looked at me and said, I don't know what you're going to say now, Mr. von Sternberg, you better be good. At any rate, I said, you do not have to have a well-founded fear to be granted asylum. And the judge's eyebrows arched. And I explained that there were provisions in the regulations providing for humanitarian relief if you could show past persecution and return to conditions of other serious harm. And it was unambiguous that there had been past persecution here. We had the physician's letter which showed that the marks on her legs came about as she said they had materialized. And we also were able to show other serious harm. She was 85 years old. There is no way that she could have survived in modern Haitian society, given the social chaos that informs that country at the time the case was presented. At any rate, to make a long story short, although the judge liked the theory, she ultimately did not grant on that basis. What she did do, however, was to wait until Congress extended temporary protected status to Haitians, and then she said, okay, this can of worms is now off my desk, and we closed the case based on the grant of TPS. But the decision illustrates a very important point, and that is that if you have a case that has substantial equities in it, you may base your case based on those equities, standing alone, if there is some showing of past serious harm. Another case that came down in this circuit, Koenig versus Ashcroft, which eventually became Koenig versus Holder, dealt with a woman who had experienced female genital mutilation in the past. She was able to show that her return to the country of origin would either cause her to bring her U.S. citizen daughter with her, in which case the citizen daughter would experience female genital mutilation, or she would be separated from the daughter, in which case the daughter would have to grow up without the guidance of the mother. The Second Circuit felt that both of those developments were sufficiently probative of other serious harm so that the board should consider them in evaluating the claimant's application. And if she could show basically that other serious psychological harm would flow to her, then that should support an application for relief. Again, these are revolutionary holdings. I ask you to please keep them in mind when you are presenting your cases because, as I say, they become much more easy to establish once you can get into humanitarian asylum. There's no longer a need to show a well-founded fear. Matter of MEVG and WGR I have summarized previously. I'd like to go through a little bit of the history of how social group happened to be applied in these two cases. Essentially, the Board of Immigration Appeals said that neither claimant could meet the social distinctions test. What is the social distinctions test? In 1985, the Board of Immigration Appeals entered its definition of social group in a celebrated case called Matter of Acosta. The Acosta said that social group consists of three disjunctive characteristics or beliefs. Immutable characteristics, associations so fundamental to the asylum seeker's identity or conscience you should not be forced to relinquish them, and finally past associations which have become immutable through the passage of time. This is where the asylum seeker has done something in the past which the persecutor will not allow the asylum seeker to forget. The persecutor continues to perceive the individual in a dire light, even though the individual has moved on from the past event. In 2006, the board entered an additional two qualifications to its celebrated Acosta holding, and that is that the characteristic relief had to be socially visible on the one hand, and two, it had to be particular. So there was a particularity requirement that was added and a social visibility requirement. The social visibility requirement was largely lambasted in the courts of appeal, particularly in the Seventh Circuit, where Judge Posner said that pretty much the board didn't really understand what it was talking about. Essentially, what the BIA was asking was for people to break cover, to show themselves to their persecutor, and thereby becoming socially visible. That, of course, defeated the ultimate purpose of the convention, which was to secure surrogate international human rights protection. So the social visibility became the subject of what I can only call judicial merriment. The board got lambasted by circuit after circuit, particularly the Seventh. And in any case, undeterred, it continued to move on, applying the social visibility requirement. Eventually, it decided it was going to rehear an important case which came to it on remand from the Third Circuit, which was called Valdivieso-Galdamez. Valdivieso-Galdamez had criticized the board, again, in terms of ignoring the fundamental purpose of social group and in joining, really, the particularity and the social visibility requirements. He's hampered, in the circuit's view, implementation of the law as it should properly be applied. So on remand, the board had to decide what it was going to do with social visibility. And what it did decide to do was to transform it. It said, we are not talking about visibility to the naked eye. We are not talking about ocular visibility. Instead, we are talking about the appreciation of the group by society. Does society see the group as being distinct? If society sees the group as being distinct, then we are going to call it a social group. Particularity also has many, many problems. There has yet to be a satisfactory interpretation of particularity coming out of the board. In any event, they ruled on the basis of these two characteristics, these two additional characteristics, particularity and social distinctions, to find, as I said earlier, that victims of gang violence in El Salvador did not have claims to international protection, and they denied the cases. Now, essentially, this really was of great concern, because advocates had said for a long time that if you're going to put things on to the Acosta test, it should be an Acosta or analysis. not an acosta and analysis. Well, in WRG and in MEVG, the board engaged in an acosta and analysis. It conjoined these two other showings. So now you have to meet all three. The acosta test plus social distinctions plus particularity, a particularly onerous burden of proof. In addition, and I think what is troublesome is that some of the circuits that had reviewed the old social visibility standard had said, well, we're really concerned about the perception of the persecutor. The perception of the persecutor is what matters most. That would have fit ideally with regard to these youths because they were clearly perceived by the gangs as being virtually political enemies to their cause. And the gangs were prepared to punish them on that basis. The board said in its decisions, MEVG and WGR, it's not the persecutor's perception that matters, it's society's. Now, there is some basis in international law for having the social perceptions test be society's test. Basically, that formulation of social perception works, I respectfully submit to you, better in gender-based cases. So, as a final sum up of what I'm going to say here, I don't expect there to be a substantial overlap into gender-based cases generated by these two decisions on social group. I think that gender-based cases will survive largely unscathed, will continue to follow the analysis that's being offered to them today. With regard to gang cases, what I would suggest to you is that you try to predicate the claim on other grounds. Political opinion, religion, and social group if you think you can meet the social distinctions test. One thing is for sure, though, the Board of Immigration Appeals did not do us any particular favors by entering these two adjudications. They were intended to crush the gang violence-related cases, and it looks as though they're going to make an enormous stride toward doing that. Thank you very much.
We'll turn to you and hear from you about statelessness.
This time in the afternoon, I figure you need a few photos. And I also wanted to put a human face on statelessness, so my photos will try to do that. Let me start by thanking CMS for inviting me to be part of today's proceedings and to particularly invite me to be on this panel with Mark and Mark, who are good friends and colleagues here in New York, and we've often worked and talked and thought together. So, my topic today is statelessness. In particular, how does statelessness fit into the U.S. refugee protection system and the gaps in that system? I want to start with a quotation from former Chief Justice Earl Warren, a quotation from 50 years ago in a somewhat less gender-sensitive time when Earl Warren said, "Citizenship is man's basic right, for it is nothing less than the right to have rights." And Earl Warren's insight, I think, tells us about the plight of the stateless individuals in the world. They don't have rights. They don't even have the right to have rights. And by that I mean in a world of nation states where citizens generally have rights, they are not only migrants, non-citizens of the state in which they live, there is no state in which they have rights. That makes them particularly vulnerable. That makes them particularly in need of protection. And that is what I submit they share with refugees, the need for protection. This is not to say that all stateless need protection, but it is to say that there is a major concern and we need to be especially sensitive to protection needs of the stateless. Now, you heard this morning that there are about 10 million stateless in the world, which is approximately the same number as there are refugees. Most of us in this room, I imagine, certainly this is true for me, I've spent several decades thinking and writing about refugees, not about the stateless people. They are in some ways in our jurisprudence, in our activism, in our resettlement, somewhat invisible. They fall somewhat between the cracks of nation states. And that's something that I think we need to try to address, try to figure out how to respond to. So, how do people become stateless? Where do these 10 million people come from? First of all, you can see it's a problem all over the world. These little thumbtacks show places where there are particular problems with statelessness, particularly intense. And you can see in our hemisphere, it tends to be less problematic than in other hemispheres. But as many of you know, the Dominican Republic recently, through their constitutional court interpretation, essentially stripped several 100,000 people of citizenship that they thought they had. Birth certificates and residency certificates that they had in the Dominican Republic. And that's one way in which people become stateless. They become stateless through government action, sometimes court interpretations, more frequently government decrees. And they're often focused on vulnerable populations whom the government feels might be not totally loyal. Another way people become stateless is through the dissolution of states and the succession of states. And as the new states form their citizenship laws, there are a lot of people who get left out. We've seen this particularly in recent years in the dissolution of the Soviet Union and former Yugoslavia. We see it also in Ethiopia and Eritrea and other places in the world. So that's another way in which people become stateless. And many people become stateless in that way. Some people become stateless because their parents didn't have the ability, because they were on the move or for other reasons, to register them at birth. So it's not clear where they were born or under whose law their citizenship should be assessed. So there are many different ways in which people can become stateless, and many more that I can talk about later. So these people in the world who are stateless, to what extent can they be protected under the U.S. protection system? They may be refugees. The 1951 Convention and U.S. statute about refugees specifically refers to people who have a well-founded fear of persecution in their country of nationality or in their country of habitual residence. So many times, and this is something I think we need to be much more sensitive to, people who are stateless fall within the standard paradigm of refugee protection, i.e. they either suffered past persecution or they have a well-founded fear of future persecution. There are two recent circuit court opinions in the United States that address this issue that I'd like to talk to you about very briefly, because I think they point the way for us to move this topic forward, move this discussion forward, and become more sensitive to statelessness issues that rise to the level of persecution. The first is Haley versus Holder in the Seventh Circuit. In this situation, a young man born and raised in Ethiopia. His parents were of Eritrean descent. After there was a referendum and Eritrea became independent, his parents moved to Eritrea and renounced Ethiopian citizenship, leaving him a teenager in Ethiopia. There later was a border war. Both countries denationalized by decree, took away citizenship of the wrong ethnic group in their country. And Mr. Haley got caught in that situation. When he came to the United States after several trips up and back from the BIA to the Seventh Circuit said he should be entitled to a presumption of persecution. He has had his citizenship taken away based on his ethnic background. If this isn't persecution, more or less, what is persecution? And I think that's extremely important, not only recognizing his case, but the significance of persecution and the fact that we should think about statelessness if it's been removed, in one of these discriminatory decrees. We should think of it as presumptively persecutory, and therefore, of course, under the U.S. asylum and refugee policy, entitled to protection in the United States. The second case, 2011, out of the Sixth Circuit, involved a woman who was born and grew up in Estonia from an ethnic Russian family. She did her medical training in, now it was formerly the Soviet Union, but in the Russian part of the Soviet Union, married a Russian citizen, came back to Estonia, lived in Estonia, and then after the Soviet Union dissolved and the Estonian and all the other former states passed new citizenship law, she kind of fell between the cracks. The case isn't exactly clear about all the details, and I think that's partly because it's so complex and the fact-finding is so difficult. But for approximately 2 years, she was stateless, and it appears that she did not apply for citizenship in Estonia, or maybe she applied and was rejected because she couldn't speak Estonian, could rather throw on a language requirement. 2 years later, in some electoral change, the law changed and she became a citizen of Estonia. Some years after that, she lost privileges to practice medicine because her Russian certificate was no longer paid attention to, and ultimately made her way to the United States. The Sixth Circuit said, in this case, I don't know, taking people's citizenship away and making them stateless is pretty bad. We think that maybe is persecution per se. The record here is a little cloudy. We want to remand it to the BIA. But although succession of states often creates statelessness, and we are not prepared to say that always is persecution, certainly when it's connected to one of the protected grounds, when there's a disparate impact on a particular ethnic group, we think that should be presumptively persecution. And I think they're right. And I think the law needs to pay attention to this, to be more attentive to people who essentially fall through the cracks. And under our current law, without changing it, they are entitled to protection in the United States. And referring back to the regulation that Mark just talked about, if you can show past persecution under 8 CFR 208.13, you are entitled to a presumption of future persecution and therefore protection in the United States. I think that regulation should be interpreted with these two cases in mind. Lastly, there are some people who are stateless, who are stranded in the United States without passports, who do not fit into the refugee paradigm, who cannot show a well-founded fear of persecution in the future, and maybe haven't been persecuted in the past. The best estimates, but they are just guesstimates, are there are roughly 4,000 people like this in the United States these days, mostly from the former Soviet Union and former Yugoslavia. What happens to these people? The answer is they get stuck in limbo. They have no passport, so they can't travel. There's no country that wants to take them back because they're not a citizen of any country anymore. They're marooned. They are effectively detained in the United States because we detain people, that we're trying to remove them, and if we can't remove them, we detain them until we figure out what else to do with them. When they are released, which is the general practice after a while, they are allowed to seek employment, but they're in a very vulnerable situation with needing to check in with, essentially like they're on probation, check in with officials, show what they've tried to do to be able to leave the United States, and the truth is, there's nothing they can do. It's not their fault that they don't have citizenship in any country. Family reunification is, of course, not in the cards. They are very precarious, they're very vulnerable. They're essentially going to be a permanent underclass unless we come up with a mechanism for responding to them. The most recent Senate bill passed a year ago this month did have such a mechanism. And I submit that that's the kind of solution we need. A legislative or maybe a regulatory, certainly some kind of policy solution DHS has been aware of this problem and actually, from what I understand, although I'm not at all on the front lines, I am in the ivory tower, interested in forging a solution, was behind the legislative proposal, which after a year of conditional lawful residence in the United States and all the appropriate background checks, would lead to lawful permanent residence, a green card, and ultimately to citizenship. I think that's something that we desperately need to attend to now. Comprehensive immigration reform doesn't look like it's coming very soon. These are a very vulnerable population that our protection system should be able to open its arms to and embrace and allow them to go on with their lives, become productive members of our community. In closing, I would just say that my look at statelessness shows me that there is so much more that we need to learn. We need to do empirical research to understand the scope of the problem and the different aspects of the problems. We need to clearly be doing academic research to understand how statelessness interacts with refugee law. And of course, we want to educate all those lawyers and judges who help move our system forward. Thanks very much.
Hey everyone, I'm Mark Nofri. I'm a fellow here at the Center for Migration Studies. I wanted to thank Karen and Mary Ellen, who was very supportive to me my time in Brooklyn, and Mark. But most of all, I wanted to thank the people here at CMS. As Karen mentioned, I'm starting a new job next week. So really, most of all, Don Kerwin, because he gave me the opportunity to be here and be a part of what he's building here at CMS. And I think all the people in this very full room are probably the best testament to that. And also Brianna and Rachel, who've been so great to work with. And I really want to thank you for the opportunity to be here. My talk today and eventual paper is on whether we can build a human rights model as regarding detention and due process for U.S. asylum seekers. The major question, can you hear me a little better? Okay. The major question overhanging here is the U.S. returning persecuted asylum seekers to their persecutors, the tortured to their torturers in some cases, because of increased detention and less due process, which leads to coercive withdrawals or mistaken denials? This probably violates international law. But secondly, can we build a system based on human rights that avoids that? The answers to those questions are probably and probably. And we'll get into a little bit more. So first, let me give an overview of the current system, which others have alluded to. Second, let's talk about the human rights standards that have come from UNHCR and others. Third, I'll give quick recommendations as to change it. But then fourth, talk about some of the evidence and research supporting this human rights model. Can we implement a model that has less detention and more due process? So, starting with the current U.S. asylum procedures. As most of you know, the standard, if there's anything like a standard asylum case, but the standard asylum claim is either brought in an affirmative application, upon which you get an asylum interview, or a defensive application if court proceedings have been started against you. That said, there are many asylum claims brought in summary processes. These are rising. Collectively, summary processes are now over 75% of all the removals the U.S. effects each year. For example, an expedited removal, if you are apprehended at or within 100 miles of a border without proper papers, generally. There were 163,000 of these in fiscal year 2012. That's 39% of all removals. A reinstatement of an old removal order, if you are apprehended after you've been ordered deported, is another 36%. There are another about 3% of administrative removals if someone is convicted of an aggravated felony and is not a lawful permanent resident. These are now most of how removal happens in the United States. And these are marked, and I should mention this all happens without an appointed lawyer, as we all know. These are generally marked with greater use of detention and not much due process, particularly in the summary processes. So, in expedited removal, detention is mandatory pending your credible fear interview, which takes about 27 days to provide on average between Border Patrol and the Asylum Office. There is case-by-case parole if you pass a credible fear interview, if you've arrived at a port of entry. And DHS does seem to grant this parole about 80% of the time, although that may include people released on bond that can't make it. But that said, there are also significant amounts of people arriving between ports of entry, formal ports. About 70% of those who have claimed credible fear since '07 fall into that category and are not eligible for parole. As to reinstatement of removal, detention is mandatory. As Anna Cabot mentioned before, you do get a reasonable fear interview to see if you can qualify for asylum. The regs say you should get it within 10 days. The average right now is 113 days, and there's currently litigation pending on that. So the concerns about detention, there are several particular to asylum seekers. One is that detention is re-traumatizing. That folks who have been persecuted arrive and are jailed, sometimes jailed again after having had that done to them in their prior country. For the most part, interviews show that they're shocked to put an asylum claim in and expect fair treatment and to be treated like that. Secondly, the indefinite nature of detention is additionally traumatizing. Studies are starting to show that indefinite detention leads to psychological trauma, hopelessness, depression, PTSD, in some cases suicidal ideations. The Swedish detainees in the study said that detention was worse than prison because at least in prison you know when you're going to get out. You have a sentence, 6 months, 1 year, and that indefinite nature is additionally traumatizing. Third, there are abusive conditions. There is a mountain of reports about these, which I won't go into here. The Border Patrol, some of you may have heard of las hielaras, the freezers, the ice boxes. When someone is apprehended by Border Patrol, they're often put into 50-degree cells. They then go into ICE detention. There are a lot of reports about that as well. ICE has, to its credit, engaged in civil reforms in some facilities like Broward in Florida. But that said, civil conditions reform does not address the problem of indefinite detention. For example, researchers who interviewed the Swedish detainees who were held in fairly good conditions, similar to civil detention in the United States or better, still reported hopelessness, PTSD, depression, because of the indefinite nature of the detention. Put another way, this is a very nice room that we're in right now. It's been freshly painted. But that said, there's a nice new floor for this conference. But that said, if we were stuck in this room and you didn't know when you were going to get out, it would be a much different story. So something to keep in mind, the conditions reform do not change the fundamental nature of detention when you're locked up. So the question is, are asylum claims getting lost in detention? Are the persecuted deterred from bringing their legitimate claims because it's simply not worth it to go through detention? We don't know, but here's what we do know. There are increased credible fear claims, there are increased detention, and there are increased claims being given up. Predominantly from these 4 countries, Mexico, El Salvador, Honduras, Guatemala. These countries showed the highest increases in credible fear claims in the last year. They are the most represented among U.S. detainees. 90% of our detainees are from these 4 countries. And these have the highest rates of withdrawal and abandonment, larger than the overall population. So there is some indicators of a correlation between detention and credible fear claims being given up. Secondly, are claims being lost in the process? There are reports in expedited removal of Border Patrol mistakenly denying credible fear referrals. Agents pressuring folks to withdraw their claims, saying if you don't sign, you'll go someplace worse. Additionally, credibility is a real concern in expedited removal. Claims are denied because someone is adding detail to their initial interview with Border Patrol when that interview was preliminary by nature. All of these lead to claims being, lost in the system. And let me just skip forward a little bit here, I'm not sure what happened.
Speaking of lost in the system.
So there is a human rights framework as to detention. UNHCR put out guidelines in 2012 that summarize the state of human rights law. Detention is a last resort with liberty the default. It is individualized, it is reasonable, it is proportional, it is non-arbitrary. Notably, detention is not outlawed. Detention to prevent flight is still legitimate, but it has to be minimal with strict time limits. Review of that detention should be ideally within 48 hours. Conditions should be humane and dignified. We should avoid jails and encourage alternatives to detention. As to due process, there are minimum procedural safeguards recommended. Being informed of charges, prompt hearing, review. There should be free legal assistance if it's provided to similarly situated nationals locked up, or access to legal counsel at all stages of an asylum proceedings. There can be accelerated procedures, but only where manifestly unfounded or abusive, and notably, not having papers is not equal to manifestly unfounded. Thus, expedited removal in the U.S. violates human rights law. Additionally, detention can't be a penalty for illegal entry. Thus, the lack of parole for those who arrive between ports of entry and their mandatory detention additionally violates human rights law, as it stands. So the human rights model is one of custody and supervision, not detention. Generally where detention is not presumed, where it's shorter, and where there are more humane conditions tailored to asylum seekers. Due process is marked by legal assistance and some targeted changes that I'll mention in my paper. Now, as to recommendations to change this, in formal in-court proceedings, the recent Senate bill did a very good job of providing some of checking detention. There are individualized assessment, there are bond hearings, there's community supervision, there's better oversight of conditions. But there are no time limits. European countries have different time limits on detention. We don't have that, except for some presumptions as to post-removal order detention. We also don't have open facilities like Europe, where there might be curfews at night, but you can come and go. Or a system where NGOs could bail out detainees. These are things in which we could learn from Europe. Secondly, as to the summary processes in detention, things that could be changed, detention could be made discretionary, not mandatory, and expedited removal. We could formalize parole guidance into regs. Folks had talked before about how the parole standard had been changed. DHS can do that because it's not formal regulation. They can change it at any time or take it away. Parole could be added between ports of entry. Most of all, perhaps detention could be shortened, and that's a function of time limits, but also resources. As I think Brian from USCIS mentioned earlier, the asylum office is swamped. And the best thing that could be done, if detention is still mandatory, to shorten the time period by which someone is detained, is simply get people hearings faster. And that would require a lot of resources to the border. But then again, detention is very expensive. The House just allocated $2.9 billion for it, and alternatives cost about 1/10 as much. So it's a question of allocation. It's not that it can't be done, it's a question of whether we want to do it. And lastly, too, Border Patrol conditions need to be addressed as well as ICE conditions. The movement on ICE conditions in the Senate bill is laudable, but there have been other bills by O'Rourke from El Paso and others that have started to address CBP conditions as well. Secondly, as to due process, if there was legal representation and assistance, it would probably go a long ways to help a lot. For example, the Senate bill has that, but it doesn't have it in expedited proceedings, and that's something that could be looked at. There could be assistance short of or addition to lawyers. There could be legal orientation presentations, caseworkers. You could have access to lawyers by video. There are ways to do this. And there are benefits beyond some of the obvious ones. Obviously, there'd be more accurate decision making. There would be less detention. There would be lawyers helping with detention hearings. For the credible fear and credibility problems that I mentioned earlier, there would be a lawyer involved in the outset as those records are being created. Perhaps most of all, having a lawyer or some human contact, a caseworker, it mitigates that hopelessness and trauma that results from detention. And that can't be understated when we're talking about a human rights model. In some cases, it doesn't need to be a lawyer. A caseworker can be very effective at that too. but someone that can give information on a case and see the way through to an endpoint. I'll note as well that there's a question, the Senate bill adds bond hearings, for example, to formal removal proceedings and some levels of review. There's a question as to whether that really helps without counsel. It's great that the Senate bill provides bond hearings. Will more people win them if they don't have a lawyer to argue them? It's a fair question. We also see too that in parole at the border, which has no review, DHS grants it in the majority of cases, perhaps about 80%, whereas with initial detention decisions and removal proceedings, DHS doesn't grant it. They tend to kick it over to the immigration court and let the court sort it out. So there's a real question, although process is good, process without lawyers may be incomplete. Lastly, am I running out of time? Or? Okay, and I may be running out of time. I'll mention very quickly, and perhaps lead into questions, as to whether the human rights model can work. One of the things research is showing is that asylum seekers are predisposed to comply with proceedings if they are treated fairly upon arrival. The theory is called procedural justice. For those of you who know Tom Tyler's work at Yale, you might be familiar with it. And the idea is that if people feel subjectively that they are treated with procedural justice, they are treated with fairly, and here we're talking about supervision and assistance rather than detention alone by yourself, that this likely fosters robust compliance with the processes and even perhaps an adverse deportation order. And there's been some preliminary research on that, but I may save that for the question. Thanks.
All right, I'll ask all of the panelists now to come back to the table. I'll thank all three of them for sticking so closely to the tight time frames when I'm sure it'll be obvious to everyone that each of them could have spoken, and given you a lot more detail on all of these points. But we've come to the time now where we are ready to take your questions, and I'll ask whoever has a question to step on up to the microphone, please, and identify yourself and start us off. Margaret, you look like you're ready to leap into action.
Well, I guess it's mainly for Mark, but the other folks can jump in too. I know in World War II there were a lot of embarrassing and horrible episodes where, for example, Jewish refugees came to the United States, got turned back, and it's documented that Hitler murdered them. And one thing I see today is there's a lack of data on what happens to people that go back. I mean, I know anecdotally, every so often you hear a story, somebody was never heard from again, after they went home, and their lawyer has no idea what happened to them. But who's out there tracking folks after they get sent back, and what's the state of the data? I know you kind of hinted that you were going to give us a little info on that.
Yeah, the state of the data is not good. There are a couple people I know focusing on post-deportation. I know Daniel Canstrom at Boston College is. I know Nancy Heemstra at Stony Brook is in Ecuador. My sense of the state of the data is not great. There's starting to be better data on what happens while people are in detention or being supervised. But that's, before they go back. Would anyone else want to comment?
I just ditto what Mark says. And in the European context, which I study a lot, there's a similar dearth of empirical evidence. There's been real efforts to try to follow what happens to people who are refooled in a kind of chain refoulement situation. And I know several reports that have 18 people who are followed, but it's just so hard to have somebody with individuals who've been turned away from the border that I don't think it's at all reliable.
Mark?
Journalists are occasionally interested in what happens, and this has been the case with victims of gang violence. Individuals who have defected from gangs and been killed have been the subject of major articles in the American press, and it was hoped that this would perhaps move the jurisprudence, but so far, no real traction.
I know there was definitely one case in Colorado a few years back that was I'm not sure if it was defection or avoiding recruitment in a gang case. I tend to think it was more recruitment. And that was well documented that the person was killed virtually immediately after their removal. but that one was reported by the lawyer who was in touch with the person and the family. So since so many of the cases don't have lawyers, I imagine it's very hard in most of them to track the data. I think I'll recognize Mr. Kerwin.
Thank you.
I already asked Mark about sovereignty earlier, but Mary Ellen, the Warren comment of citizenship is the right to have rights. I want to take off on that a little bit, because what that means is that sovereignty is about the protection of rights and the rights of citizens, it seems to me. And it's not the way we normally think about sovereignty or talk about sovereignty, or hear, people talk about sovereignty in the immigration field. It's all about national defense and keeping people out and all of that. So it leads me to ask, is there kind of a vision of sovereignty here, or a concept of sovereignty that extends that right to have rights beyond just citizenship, And I wonder if you think about that at all in terms of your work on stateless people.
The answer is yes, I think about it, and the answer is, I love Earl Warren's quote, but I also think it's limited for the reason you just suggested. I think in terms of international human rights, your human rights shouldn't depend upon whether you're a citizen of a sovereign state or not. In the real world, however, the ability to have rights usually is, or let me say it the other way, if you have rights, you really want to be able to access rights, and very frequently people who are non-citizens have great difficulty accessing rights. So to your general question, I think we shouldn't limit rights to those given by sovereigns, but we should pay special attention to the vulnerabilities of people who have no sovereign to fall back on.
Anastasia Brown, U.S. Conference of Catholic Bishops. I have a question on the statelessness and relation to refugee law that I wondered if you'd come across, which is the definition of country of last habitual residence. Oftentimes a stateless refugee may be in a country, but they don't actually have any legal status there. However, the interpretation could lead to you aren't being persecuted there. You simply don't have status there. I'm wondering if that has come into your world.
Yes, and let me confess to you all, I am new to looking at statelessness, so I don't claim to have an encyclopedic knowledge of it, or a total familiarity with aspects of how statelessness and refugee law intersect. But in another article I wrote where I was looking at British and Canadian responses to statelessness, there were definitely more examples of situations of people who were stateless who had been, for example, this often seemed to happen more frequently in the Middle East, who had been habitually resident in one country, not their country of citizenship, for a long time, had been born perhaps in another country, let's say Lebanon, and Lebanon may or may not let them back in. And one of the big issues that was being examined by the Canadian courts and the Refugee Board in Canada was whether withdrawal of residence status in that kind of situation was in fact persecutory. And I think that there are many examples where somebody who has been a long-time resident who's suddenly not allowed to work anymore, essentially expelled from the country, where that can be viewed as persecution itself.
Yes, please go ahead.
Hi, Deb Stein, Episcopal Migration Ministries, and my question is about detention, alternatives to detention. I was wondering, as you were speaking, how likely it is, I mean, in all of these things, all of us are fighting for a lot of legislative fixes and some remedies for many of these things. And in terms of detention, where does the kind of very powerful prison industrial complex lobby play into any either your research or recommendations? How likely, I guess is what I'm asking, how likely is it to even change any of those things when you have such a powerful, it's not even, they're hard to defeat. So how likely is it to change automatic detention when there's so much force working against that?
That's a good question. You know, this year, I think the answer is not likely. I mean, there are some reforms that, as we mentioned, that would happen if the Senate bill passed. It doesn't look like it will. In the long run, the role of the prison industrial complex is a complex one. There's certainly, you know, right now you have private prison companies which are lobbying elected officials for more immigration detention. There are some that have argued, well, you know, this isn't all that different from the prison guard unions. Maybe it doesn't add something, maybe it does. That's contested. A cynical view would be that reform is likely because at least one of the private prison companies also owns the electronic tracking bracelets. Geo Group owns BI, that has the contract with the federal government. You know, I mean, a larger view is that the hope is that, you know, there are models that develop around the world that we can learn from. As I mentioned, in Europe, there are open detention centers or semi-secure detention centers. You know, detention beyond the four walls, which may pose its own problems. I mean, you know, we then start talking about whether mass detention is leading to mass supervision, and that poses perhaps a different set of problems. But, you know, and secondly, that I think the evidence has to be produced. You know, can alternatives to detention work? Most of the very limited evidence out there shows that they can in certain situations. There's certainly a fair amount of evidence in the criminal justice world that shows that alternatives to detention can work, particularly if combined with a robust risk assessment that predicts flight and public safety. There's very little research on whether those findings, and again, as I mentioned, findings that if people are treated fairly, they tend to show up for proceedings and not commit crimes, whether those transfer over to the immigration field. You know, historically in the immigration field, the presumption has been basically that immigrants are either non-citizen absconders or non-citizen criminals. That there's more justification for detention than in the criminal world. One of the things the criminal world provided is at least a baseline to show, well, if it's being done here, it might be different here, but it's probably not so much different that we should employ detention on such a grander scale. But those studies haven't been done yet, and that's, I mean, part of my research focuses on that, and others as well.
I think Mark's point is important. While we're always talking about alternatives to detention and trying to have detention in the least restrictive means possible in as many cases as possible, we have to be careful not to lose sight of the question of who needs to be detained at all and re-examining the necessity for mandatory detention and looking at that question as well as the electronic and other alternatives to the four walls of detention. Next question, please.
Sandra Lamiri Singh, Georgetown University. Thank you very much for all of your very informative presentations. But Mary Ellen, my question's also to you on statelessness. Are you aware of any jurisprudence where gender-based discrimination in nationality laws have been seen on its face as a form of persecution as well? The examples you gave related to ethnicity, and I was wondering whether gender had come into it at all.
I haven't seen any jurisprudence or other reports where gender-based discrimination in nationality laws was viewed as per se persecutory. But I have seen a lot of sensitivity in the discussions that many of this, not many, but there are still far too many countries in which the gender-based citizenship and nationality laws can lead people to statelessness, so making particularly vulnerable populations. But I don't think that's actually yet teed up. I think we're just at the beginning of trying to understand and litigate and come up with policies in response to these statelessness conditions.
We still have time for a few more questions, but I'm going to take the liberty of asking Mary Ellen another one while we're on this topic. We, as asylum practitioners, we're always looking to refugee law, and we're always saying the exact, you know, the definition, the test is exactly the same. What someone has to prove, to be eligible for asylum is that they satisfy the definition of a refugee. And you talked about the 2 circuit court cases in the U.S. in the asylum context where statelessness issues played in to at least a remand and a reexamination of the impact. And I wanted to ask if you're aware of cases or standards or specific examination of this statelessness question in the refugee processing context. I know that it's not the focus of your work, but I wondered if there's a parallel examination there.
I think there should be, I don't know whether there is.
Okay. That's a fair answer, and I'm sorry to have put you on the spot. Yes, next
My
question.
question is for Mark. It's actually a comment. I'm in LIRS, and we have actually a really great alternatives detention program where it's 7 hub sites. It's community support, and we actually connect released detainees to nonprofits. And ICE has actually shown a proclivity to let folks go if we can demonstrate housing. What, as someone that's relatively new to the field, what's been surprising to me is that there aren't many real strong connections between universities and NGOs in terms of tracking data. So we are about to undergo a study with about 100, or actually it's underway right now, but it's going to be very small. And I guess it's just a comment for those of you in academia to try and find us more and connect with us more, and anything that you can do or any comments that you have on that would be really powerful, I think, for all of us.
That's excellent. Yeah, the LIRS model is actually something that's mentioned in my paper draft right now of where the system could head. I think I mentioned NGOs bailing out detainees, and yours was the model I was thinking of. But that's great that you're exploring partnerships with universities to collect data and track it and start reporting success rates and failure rates and as to who. My sense, now this also may be depending on your working relationship with ICE, my sense is that ICE has a lot of very granular data that would be helpful to academic researchers if they released it. And for example, I've done some FOIA requests on the risk assessments that they're doing, and I've gotten some samples and extremely granular, helpful data as to discovering what happens in their process. If you can have a relationship with ICE where they could turn over some of that to you, that's even better. Sometimes those can be tricky. But yeah, there's a lot of, yeah, I mean, this is something we should talk about afterwards, because there's a lot of research that can be done. I think the other thing is that it's hard to find research on what happens if people are not detained post-removal order, you know, if they're actually given alternatives, because ICE is just simply reluctant to participate in a study like that, you know, and that's, I mean, at some point, that's also part of the story too. That also happened when Vera did their study in 2000, which still represents the best quantitative study of asylum seekers and alternatives to detention out there. That's 14 years ago now. You know, INS, they had run into some of those issues with INS as well. I mean, so there are issues to work through.
And I think it's also an important reminder to the lawyers that while we focus, and not wrongly, on access to counsel as such a big determinant of what happens in proceedings, both in terms of compliance and in outcomes, that it's not the only thing. That housing and contact with families and the ability to work and that more holistic group of social services is also important and a part of the whole package that we need to be considering.
Yeah, you know, building on that, I mean, the research right now, it's mostly qualitative. There's a UNHCR-sponsored research in Toronto and Geneva with asylum seekers. It basically shows that if someone arrives as an asylum seeker, they're predisposed to comply. In many ways, their asylum claim is a manifestation of faith in process and fairness. If they arrive and are treated fairly and with dignity, they are more predisposed to comply with whatever order comes out of that. You know, there are quotes like, well, you know, now that I understand the process, I know I've been given a fair shake. I know not everyone's going to get asylum, but I just want a fair shake. There are quotes like that. That said, if they are arrive and are treated with detention, the dynamic immediately and sometimes irrevocably changes. So that all of that, I mean, the first reaction is generally the most important. So that if someone is treated with detention and then released, which is the case with expedited removal now, they are less likely to comply because they are less trusting in the system from the outset and more likely to abscond from the system that has treated them unfairly, they perceive.
Yep, I know we have one more question.
Really quick, this is actually also a question for you, and it's about what you were sharing about rates of abandonment and how they're higher for asylum seekers from Mexico and the Northern Triangle of Central America. And we also hear anecdotes of people being encouraged to withdraw their petitions, and so I think that I'm also predisposed to hear that as a symptom of there being a problem in the process. But I've also been in meetings where folks from a different perspective have said that that's evidence that they were fraudulent claims to begin with. And so I was wondering, so I don't know if that makes sense, that you can kind of interpret those higher rates of abandonment either way. And so I was wondering if you have any kind of comparative data other than from perhaps other countries that have different kinds of asylum processes that would give us some way to interpret that kind of on either side.
No, I don't think so, but that's a great point. I don't know. Do you know anybody?
Well, I don't know of comparative data per se, but I think there is, I think the EU with its, in the past essentially 10 years, has developed a lot of new asylum laws and is tracking data in all 28 EU countries. And I think that's a potential resource that we can look at. And with regard to kind of detention and other issues that would shed some potential light on different approaches.
Right, and that brings up a good, I mean, as you say, there are two ways to read the statistics I put up there from Mexico, El Salvador, Honduras, Guatemala. One is that there are more people being legitimately persecuted and bringing claims and sometimes giving them up. Two is that there are more fraudulent claims from those four countries. Probably when we have congressional hearings in a couple of weeks, we'll hear both of those stated from the podium. And I think that's where, I mean, as you said, if LARS can start to compile data on things like that, that's extremely, extremely helpful.
And I want to give Mark here the chance, if like you wanted to say a word, and I'll make it the last word.
Well, I'm simply going to say that at the outset of any inquiry, when somebody arrives at the shores of any state, international law reposes on the state the responsibility to ascertain whether or not there is a concern about returning. It is not up to the alien to do this. It is up to the state. And if the state doesn't launch appropriate inquiries at this stage, it itself is probably culpable of refoulement in violation of Article 33 of the Convention, or Article 3 of the Convention Against Torture, or any other surrogate international human rights instrument that may apply in the premises. But that is the responsibility of the sovereign and not of the individual seeking a remedy.
Thank you, Mark. I think we're out of time, so I'm going to ask all of you to please join me in thanking these